Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
We bring the jury.
Hello, everyone. Happy Monday. Hello, hello, hello. I wasn't supposed to be here today. I was supposed to be getting my hair cut. And then my appointment got canceled. So I'm stuck with this until October. Isn't that fun? Isn't that fun? But that's okay, because that gives us more time to talk about O'Keefe v. Karen Reed wrongful death lawsuit. And I spent all weekend reading all of the documents for you guys and made a slideshow. Because I remember in the last one, I was like, man, it would be really nice if we had visuals because it's a lot of people, a lot of defendants, a whole lot of lawyers, a whole lot of other interested parties that it gets confusing very quickly. So I also made a slideshow with us for the timeline and who is who, and hopefully that will help us out in the future of trying to cover all of these lawsuits because there's 4 and they are all crazy. So, buckle up for that because, oh my goodness. Oh, what a headache is all I have to say about all of that. What a freaking headache. But before we get into it, hello, Mary. Good morning. Good morning. Wings. Good morning to both of you. We are doing this only on Couch Court with Llama today. Anything that's not Laura Owens or Bam for now is going to be here on this little channel. So we got a little bit smaller private room with all of us in it. Hi, Stringer. Hello. Good morning. Happy to see you here. Hope you're doing well today. Buffy is not with us today because she already had other plans and we weren't supposed to have a show. So it's just me today, which is fine. I can sometimes have enough snark for both of us. Maybe she'll join later. I don't remember exactly what she said her plans were, but either way, she is busy. I was like, well, you know what? Whatever. I miss my friends, so it's fine. I hope you all had a good weekend. As I said, mine was sitting here working all weekend. I was in quite the rabbit hole. And then next weekend, I'm meeting up with some of my friends, Amos, Annie. Their husbands are coming down. So we're going to have a nice little weekend party. So I have so much to look forward to this week. I'm very excited. Oh, you love the shirt? Actually, you know, it's so funny. It says rock bottom, but it's like it's a Bob's SpongeBob shirt. It's my son's shirt. I just realized it, like, when I put it on, I was just like, "Oh, I guess this isn't mine." And now he's a big grown boy, and, we wear the same size clothes now. So there's that. But I'll let him know that you liked the shirt. Um, Anywho, so let's go ahead and get into it. So there is a hearing, a status conference hearing on Thursday morning. I don't know if it's going to be much of anything. Based on the length of a lot of the most recent hearings, it's usually like 10 to 30 minutes, though it seems like some of the other hearings were very spicy. So just because it's not long doesn't mean it doesn't say a lot. So we are going to try to hit this case really hard this week. And then next week, we'll have our variety of cases and whatnot. So, as we said in the last episode, this case started, you like it even more knowing it's SpongeBob. I know, right? Oh gosh, when I tuned in for Big Brother and they were talking about SpongeBob's greatest hits, I was just like, oh my God. Why the one day in a week and a half I finally get to tune in and it's SpongeBob talk. Anyway, sorry. I'm gonna be a little all over the place because I just woke up. So, hello, Negla. Good morning. Good morning. So, regarding this wrongful death suit, so the O'Keefe family are the plaintiffs in this case. Oh, wait, hold on. That's right, Llama. You spent all this time doing it this weekend. Here we go. Look at that. Ooh, that's right. Visuals, friends. Visuals. That's how much I care about you. And for me too. Oh, let's see. Does this one do better? That one's more centered. Well, actually, no, we'll do that one because we do have stuff to read on them. Hi, Buffy. See, good morning. There she is. Busy, but here. So the O'Keefe family, that would be John's estate, his brother Paul, his mom Margaret, his dad John II, and Kaylee, his niece, are all suing Karen Reed, C.F. McCarthy's, and the Waterfall Bar and Grill. Those were the two places that Karen and John were at with some of the house defendants. They go by a lot of names. um, they are suing them for wrongful death. And we went over the beginning of this lawsuit, and the family, even though this was filed in between her first and second trial. The first trial was a mistrial, and then the second trial, she was found not guilty and acquitted of murder. She's found guilty for the DUI, which everybody expected, and comparatively to the other charges, it really wasn't a bad deal at all. So they filed this one in between, and they are, blaming Karen basically with the state's story, with their version of events, which for many of us who watched the trial, it was outlandish. We'll just put it that way. They did not convince me of anything. Actually, the only thing they convinced me of was the amount of corruption, really. It was astounding. I know some of you had said you hadn't watched the trials. I can't stress enough. I can't stress enough how wild they are. Okay. I can't. It's truly unbelievable. So definitely watch those if you haven't while you're waiting. So they're saying that she hit him with her car, left him to die in the snow, woke up his niece at 4:30 in the morning, yelling at her that John is dead, and I need to go. And that's why Kaylee is in this lawsuit, because suing for intentional affliction of emotional distress. Though the judge had kind of threw out part of that claim on one, but not the other. It was a mess. Do you think Karen was blamed just because she was unlikable and drunk with the House defendants? I mean, if like that's the side I'm on, that there was way more to this. I think she was easy to be blamed because she was an outsider to the friend group, and I mean John was too. John didn't really know the guys in the house really. He knew Jen McCabe and he knew Carrie Roberts. Um, but I don't think he really had much of a relationship with anyone else per se. So I think it was partially she was easy. She left. She was drunk, and they didn't really care for her that much. So they were going to blame Lucky if Karen wasn't there. That's right, the snowplow driver, Lucky. There's such a cast of characters. And guess what? All these cast of characters come back up in these lawsuits because everybody is suing everybody in this case. But yeah, that's true. They probably would have been like, oh, he was hit by a plow or, you know, whatever. They would have found something, I'm sure, to blame besides themselves. I mean, I very much think that something happened inside that house and that Karen is factually innocent, but it doesn't really matter because either way, she was found not guilty, and the state did not prove anything at all, in my opinion. Though I know there are many people that have differing opinions, and that's okay too. Actually, I would be very interested in which parts of the trial uh, made you lean towards guilty. I'd be interested in what that is. Not in a confrontational way, but certainly always interested to hear other people's perspectives. All right, so back to this. So the O'Keefe family is suing Karen, the bars, all of that fun stuff. Hi, Terry. Good morning. And we finished off in 2025, where the judge had decided that they were trying to get this case dismissed, Karen was, and the judge rejected most of their arguments, except for, well, they said the whole family can move forward with these claims. One of the claims with the niece, Kaylee, was thrown out because she had only heard speculation that John might be hurt early in the morning rather than actually seeing him injured or encountering his body because she left him at home, which again, the plaintiffs were just like, and she left a 14-year-old girl all home alone. And we're like, well, what did you want from her? What did you want Karen to do? You want her to take the 14-year-old out in the car in the middle of a blizzard to go find her dead uncle? Like, that's even worse. Let alone both Karen and John left the kids at home while they went to the bar. I don't have a problem with it. She was 14 years old. So, but it's like it's a no-win situation for Karen regarding the plaintiff's stance on this because it was like, what it would have been even more inappropriate to take the 14-year-old with you to look for her uncle at 4:30 in the morning. But then the judge had ruled that, everything can move forward. They'll hear more of it, including Kaylee's reckless and intentional emotional distress. So that's where we are. Now we are in October 8th, 2025 of this timeline. It goes very quickly, guys, very quickly. And I am supposed to be off today, but my hair appointment got canceled until October. Mm. Boo. So that's why I'm here today. So let's see. You have thoughts about that? About what? About which thing? Sorry, I said lots of things. And I was up very late last night watching House of the Dragons coverage because it was amazing. Oh, the dragon fight was just so cool. Anyway, I won't get into House of the Dragons no matter how much I want to talk about it, but it was awesome. It was awesome, is all I have to say. Awesome and sad. Oh, it was everything. Anyway, so we are on October 8th. And the only significant thing of this day is that the plaintiffs asked the judge to grant, I think her name is Bibian Fell, which I've never heard of that name, but I like it. Bibian, by the way, very unique, cute name. Attorney from California to join their team, Pro Hoc Vice, with Mark Diller as a sponsor. I don't think Say Cheese is here yet, but when she listens to this later, I hope you're proud of me, girl, for saying it right. Oh, about why they're suing about keeping, Kaylee up. No spoilers, you won't get I just said there was a dragon fight, that was it, and it was awesome. No spoilers over here from me. No, ma'am. That's why you don't like being in the chat. Oh, look, what I forget how I said your name last time, but hey, happy to see you again. You say that you believe Karen did it, but I'm on the manslaughter side of things. I believe she had no intent and no memory of what happened. I also believe the cops are corrupt. Both sides have good points. Fair, fair. And I appreciate you sharing your opinion, even though it is different than mine. I like a variety of opinions. And I think those are some, you know, fair points of it all. Because you can think that the investigation and the cops were corrupt and have other thoughts about the case. Because that part is really ugh, not up for debate, their investigation skills. But happy to see you back, though. Thank you. I hope you had a great weekend. All right. So Vivian Fell joins the plaintiff's team. And as you can see, I put the cute little, oh, wait, let me get rid of that llama because it's in the way today. There we go. I'll have to put the llama somewhere else. We have the plaintiffs here up at the top. So that way, in case you didn't watch the trial, like I know some of you haven't, this will give you a big, like, oh, yeah, that person and that person, because I need that. And then on October 21st, Karen files her answer to the original complaint finally after over a year, because it did get put on hold with her second trial and she was put on stay for the civil lawsuit until that was over, along with her family members. But she finally answered, and it was literally every word was denied over and over and over again, which is typical. Uh, Everybody that files an answer is always denied, denied, denied. So it is really not a surprise. Yeah, that's true. We do have differing opinions. Oh, you like the slides? Thank you. I was a very busy llama this weekend. I don't even know how many slides there are. There's like over 100. All right. So she denies everything. Totally normal. So did the waterfall and CF McCarthy's. So pretty standard there. And then on October 31st, 2025, we have a bit of a attorney tag team in and out for Karen. So her original lawyers, Christopher George, Marissa Palladini, and William Cavell, withdraw from her case, though we still have Damon, um, Allen, Elizabeth Little, Caleb Mason, and I don't know if Aaron Rosenberg has come on yet. I kind of forget, but whatever. She adds 4 more to her team. Michael Bell, Thomas Tang, Sarah Shipley, and Arthur Maravellis. I think that's how you say their names. All from the same law firm there. So I think that puts a total of 9 attorneys on Karen's side of this. There's, like I said, multiple attorneys for everybody, a whole legal teams, which when you find out how much discovery there is, you're going to be like, okay, yeah, that definitely. I don't even think that's enough. Are they hiring to go through documents? Because I'm available. I'm available. I love spreadsheets. I love all of that. I am available to go through what is millions of pages of documents. Yeah, yeah. I'm a visual learner too. Yeah. Well, thank you. I'm going to call you Lee. Is that okay? Lee? Tell me which one you want. What do you want me to call you? I'll call you whatever you want. Allie? I don't know. You're doing a great job with this. I'm enjoying your coverage. And yes, Proctor openly admitted he liked to plant evidence on suspects he didn't like, and he didn't like Karen Reed. Oh boy, wait, I know you know, but some of the others, they don't know just how deplorable, disgraced former trooper Proctor is, because it's awful what a gross human being he is. But thank you. I appreciate that. All right, so her lawyers swap in and out. Not that surprising. It could have, I mean, I don't know. I don't want to speculate on all the reasons, but it could have just been too much. Maybe they didn't have time. Who knows? As you see, a bunch of lawyers will come in and out constantly. So then on November 14th, 2024, the original judge on the case, Judge Daniel O'Shea, is retiring, and the case is assigned to Judge Mark C. Gildea, right? Is it Gildea? I don't know everybody's names, so I'm going to say however I think it is, and then y'all can correct me afterwards. It's fine. I will learn. But I think it's Gildea. So he is now the new judge on the case. I've heard people don't like him. I've heard he's worse than Bev, but I don't know. I haven't seen any of this stuff yet because I've not watched the hearings. So I don't have an opinion on that yet. But I have heard it's not great. So we'll see. Gilday. Oh, jeez. But it looks like Gildea. All right, Gilday. Gilday it is, friends. Gilday. All right, I think I got it now. Then on November 19th, we got Alexandra Beaton joins the defense team for CF McCarthy's. Look at that. Another new attorney. They already have some other attorneys that we talked about last time, but I was not about to go and remake all of those. So we'll see. Hello, Annie. Hey, girl. Happy to see you here. I don't know. That's what I've heard. I've heard he's worse than that, but I don't know. We'll see. And then they have, after she joins the CF McCarthy's team, they have a conference on November 21st, a conference to review status. I didn't find any audio or video from it. So I don't know what happened. I feel like during this time I saw, was it Melanie Little? I want to say it was like a call in and watch, but they couldn't stream it. And so she was just like relaying what was said. I feel like that might have been around this time. But it was also probably just the new judge wanting to get caught up on everyone. So it was nothing burger. I mean, there wasn't even like orders out from it or anything. So I imagine that's what that is. Oh, he's awful. He's legit awful. Oh my goodness. Hi, Jupiter. Good morning, babes. Hope you're doing well today. Happy to see you here. So then on November 25th, 2025, we get into Karen Reed's memorandum of law in support of motion to compel disgraced former trooper Michael Proctor to produce documents pursuant to subpoenas. Yep, that fucking guy. Oh, we all hate him. He sucks. Don't worry. He's worse than you could possibly imagine if you don't know anything about him. And we'll get into when we get to Karen's lawsuit against Massachusetts State Police and the Canton Police Department, which she just filed in June. It's unbelievable. It is unbelievable what this mofo had the balls to say constantly on his work stuff. But we'll save that for then. Because boy, we didn't like him before. The whole country hates him now. So all right. So Karen, this is Karen filing this. I tried to make it so whoever's filing is on the left side, to remember who's filing what when, because like I said, there's a bunch of different sides and they're all filing stuff at the same time, and it gets very confusing of whose was whose. It's already hard enough when there's one plaintiff and one defendant, let alone 1 and 3 plus a whole bunch of other parties. Don't worry, his lawyer is going to say some stuff too. So, for this document, Karen is asking the court to force disgraced former Massachusetts State Police Trooper Michael Proctor to hand over documents that she officially requested months ago. Now, Karen sent Proctor two separate subpoenas. The first was hand delivered in July 2025, and the second was delivered in October 2025. Now, for those of us that know, we know why he's not responding to any of these, probably because of what just came out a few months ago, and we're like, okay, yeah. Could it get worse with him? Yes. The answer is yes. It very much did get worse. No wonder he doesn't want to cooperate. But if you're gonna say all that shit, then you might as well just sit there all proud, then, boy. All right, you'll s- you'll know later. It's fucked. Hi, Amos. Good morning. Hope you're doing well today, babes. Happy to see you here. So Proctor then acknowledged that I'm doing a slideshow and reading at the same time, guys. So I'm doing my best. Proctor acknowledged that he received the request and asked for multiple extensions. However, he has missed all the agreed upon deadlines, has not provided a meaningful response, and has not handed over a single document. No, no, he wouldn't. Why would he do that? Now, we know that the family is saying that Karen has created a false narrative and conspiracy plot to clear her name. Karen is trying to defend herself by proving her narrative about the investigation is actually true. It was, quite frankly, one of the worst investigations. It was pretty bad. But she targets Proctor because he was the lead police investigator in the case that originally led to her arrest. Now, Karen's first subpoena required Proctor to sit for a deposition and turn over all records, texts, and emails regarding Karen, John O'Keefe, the the death investigation, and other potential witnesses by August of last year. So that's a lot to turn over. You would think that because we've already done the trial and stuff, he would, but we all know why. We all know why stuff's not getting turned over by any of these people. So, including Karen, in my opinion. Now, an attorney representing Proctor in his administrative appeal for his job, because remember, they were trying to fire him because he's a piece of shit. And he tried to fight it, but then he didn't anymore. And we all know why that is too. An attorney representing Proctor in his administrative panel or appeal for his job asked for a week-long extension, which Karen's team allowed. However, that attorney never followed up and stopped responding to emails. In September, the same law firm clarified they were not officially hired to represent Proctor in this specific case, and no new lawyer came forward, and Proctor ignored the request. Shocking. Just so shocking. Karen then sent him a second subpoena asking for specific documents again regarding information from. Oh, oh yeah, I guess it's not working. Hmm. What? Are we back? Are we back and working? Are we back? Maybe. Maybe not. Hmm? All right. It's working now. I don't know what that was about. That was very everything was fine on my end. So it's Monday, friends. It really wouldn't be a Monday if there weren't technical difficulties. Like for real. Every Monday, it's like that. So I don't know what that was about, but we're back now. And I don't know where I left off because it was all fine over here. So of course it did. Of course, of course. Let's see. Where did we leave off here? Well, it's okay. We're still kind of in the same spot anyway. So basically, Proctor doesn't have a lawyer, and he dropped his appeal for his job back from Massachusetts State Police, which most of us know why he did that now. So there's that. I got my thing running over here, so that with my stream running over here, so that way if it happens again, I might know ahead of time that it's not working. So hello, Carmen, not Electra. No, no, I don't know why it happened, but that's okay. We're here. All right. The last thing was that Karen sent a second subpoena. And then, yes, okay. He ignored it. He didn't have a lawyer and he dropped his appeal. So after the second request, Proctor called Reed's lawyers directly, explaining that he did not have a lawyer yet and needed more time. Karen's team agreed not to file a motion in court immediately to give him time to hire someone, which I guess you didn't hear. I said that was very nice of them, considering how much of a POS Michael fucking Proctor is. So that was very nice of them. By the end of October 2025, Proctor called again, claiming that another motion filed by Reed scared off the lawyer he wanted to hire. He asked for even more time. Bro, there's a reason why the lawyers don't want to represent you because you're garbage. You're garbage. Your words are trash. Um, I think that's kind of funny that no lawyers want to represent them because if I think anybody should have some bad karma, it's this guy. And trust me, again, not liking him is very much warranted. Um, not only from what we know in the trial, but what has then since came out in discovery from these other lawsuits. He was worse than any of us could have possibly imagined. Now the question is who knew what for how long? Um, so then Karen's lawyers refused to grant further delays because the original documents were already 3 months overdue, and Proctor has never formally objected to the request. You guys, he just wants to cooperate, but he can't get a lawyer because he sucks. And what is he gonna do? Oh, Spectrum. I don't know if that's who we have. No, we have AT&T now. We did have Spectrum, and then we switched to AT&T Fiber. So, hi, say cheese. Good morning. Welcome. Happy to see you here today, babe. Hope you're doing well. So, that is that for her motion there. Now, then on December 2nd, Karen reads memorandum of law in support of motion to compel the Norfolk District Attorney's Office to produce data in response to the subpoena. Now, sorry, my throat's a little today. Now, if there is one thing about this case and all the others, is that nobody wants to hand over anything. Nobody wants to hand over anything. Nobody wants to talk about anything. Nobody on all sides, by the way, all sides. Nobody, everybody's like, no, which is, it gets a little annoying real quick. I mean, I get some of it, but the others, it's just like, come on, come on. Angela, Angela's Negla autocorrected by my iPhone. That's better than Terry calling her Nick. Actually, Negla goes by many different names in the chat, I guess, depending who's talking. She'll answer to anything, it seems like. All right. So again, this is submitted by Karen, hence her being on the left here. Laura McLaughlin is the attorney representing the Norfolk District Attorney's Office. And Michael Proctor's there because this is about him again. So Karen in this one is asking the court to order the Norfolk District Attorney's Office to hand over all data extracted from cell phones owned or used by Michael Proctor, a former state police trooper. Disgraceful. Karen sent a subpoena to the NDAO asking for all of Proctor's phone and iCloud communications. While the DA's office has shared some documents, they have refused to turn over the contents of Proctor's cell phone. Now we know why. We know why. During Karen's criminal trial, oh, hold on, next slide. There we go. During Karen's criminal trial, a separate law enforcement agency shared a small batch of Proctor's text messages where, he said a lot of really not great things about Karen. So there was that. Call me, call me anything, but don't call me late for happy hour. I love you, Nekla. Besties. Same girl. So those messages showed Proctor making highly inappropriate, crude, and sexist comments about Karen, to which they made him read them out loud in the first trial. They were awful. And if you thought those were bad, wait till you find out what they reveal much later, because it's a billion times worse than that. And it revealed that he decided she was guilty almost immediately without doing a proper investigation. Now, recently, the DA's office reviewed new data from Proctor's private cell phone and labeled it highly sensitive. Well, it's because the whole world was about to hate him more than they already did, but okay. When the DA's office showed this data to Proctor, he suddenly dropped his legal fight against being fired from the state police. Yeah. The information also caused the Canton Police Department to put a high ranking first responder on leave. That's any indication to how bad and fucked up it is. That's how bad. Hi, Christine. Good morning. Hope you're doing well today, babes. Happy to see you here. Happy Monday. Make room on the couch for Couch Potato Christine, who's here. So the DA's office has acknowledged that they have the data, but they refuse to give it to Karen. They claim they cannot share it because of a protective secrecy order placed on it in a completely unrelated criminal case, meaning they can only hand it over if the judge in this case commands them to do so, which I don't know if that's true or not, probably. But also regarding disgraced former trooper Michael Proctor, once we talk about that other lawsuit and you hear what he has to say, I think my theory is that even the DA's office didn't want these to come out because they are so horrific that I would imagine that there are probably many people that he investigated their case that are probably trying to get an appeal because of how egregious his messages were. Not only about Karen, but other things. Would not surprise me one bit. They did not want these getting out because it is not, the word bias is an understatement. So I think that's their motivation for that, because yikes. Karen's lawyers argue that under civil court rules, she has a right to any non-secret information that could prove her defense, because the family is suing her from making false claims about a corrupt police investigation. She is legally entitled to gather evidence, like Proctor's text messages, to prove that her claims about the investigation are True. By the way, there are going to be some typos and misspelled words in this slideshow, just to let you know. But it's fine. All right. It's fine. It's Buffy. Is the unrelated case the Miles King case? Because I think it is. It probably is. It most definitely is. While I don't know much about that case, I can assure you it's certainly that one. It's certainly that one. Probably along with some others, as I said too. But that's another Massachusetts case. Same place. That is also very questionable. So that is Karen's argument about the district attorney's office. So then the district attorney's office files their opposition to it. And they say that the request by Karen is too broad, that Karen is asking for all data on the phone rather than limiting her request to information specifically about herself or the investigation into John O'Keefe's death. Though we'll say the other stuff Proctor says is probably relevant to really prove the bias and racism and sexism that's in all of his stuff. But okay. They say that it invades privacy and legal privileges because the phone contains years of personal information, some of which dates back to before Proctor was a police officer. It also includes private, legally protected conversations, such as talks between Proctor and his wife, spousal privilege, and Proctor and his lawyers, attorney client privilege, which most phones contain those things. There's protocols to deal with it, but okay, sure. They then claim that it is an unfair burden on public resources because the NDAO has limited staff and resources. It's an undue burden. When you spent millions of dollars to try Karen Reed, not once, but twice. You had no problem digging in your resource bank to pay Hank Brennan over $500,000 to prosecute this case. But you're right. You're right. You don't have the resources, the staff. No. Sorry, I do not like any of these people. I got questions. So the NDAO are already under strict court orders in separate criminal cases to carefully review this massive amount of phone data to protect private information before sharing relevant pieces. They argue it is too burdensome to do an entirely separate review for this civil case. I mean, oh well. That's how I feel. Sorry, not sorry, but like, hey, this guy comes up in a whole lot of your cases. I would be fucking going over every single thing because he's probably fucked numerous people, let alone a bunch of prosecutors trying cases that are probably open book or closed book, whatever. Um, Open and closed, easy cases. But because Proctor had something to do with them, not going to be that way. Let's see. The NDAO points out that Karen had already sent a subpoena directly to Michael Proctor himself, who actually owns the records and is in a better position to argue what should and shouldn't be shared. Is he, though? Is he in a better position to argue that? Ugh, okay. I wouldn't trust anything he gave to me. The NDAO notes that they are not completely refusing to cooperate with the lawsuit. They are already handing over a massive hard drive containing about 2.5 terabytes of data from the resolved criminal case, which includes information from Proctor's work call phone. The NDAO wants the judge to block Reed's request, and if the judge won't block it entirely, then they ask to stay the request until they finish reviewing the phone data for their ongoing criminal cases. They suggest Karen should have to submit a much narrower request that only asks for specific categories of data within a restricted time frame, which again they usually do. But yeah, ongoing criminal cases. It's bad news bears when these kind of texts can really disrupt everything else. But there's certainly reasons why even the district attorney's office does not want his messages coming out because it is not good for them either. All right, so that was their back and forth to that. Then on December 15th, 2025, just this past December, the plaintiffs, the O'Keefe family, file a memorandum in support of motion to compel further answers to interrogatories from defendant Karen Reed, which are just like questions, right? Question one, this is their question, and then you send in like a written response. That's what those are. But apparently that's the fancy word for them. So they say that Paul O'Keefe, representing the estate of John O'Keefe, is asking the court to legally force Karen to provide detailed sworn answers to a specific pretrial question. Now, Karen has formally claimed as part of her defense that John O'Keefe's death was actually caused by other people, third parties, the House defendants, and not her. The plaintiff wants her to provide the specific facts she has to back up this claim under oath. The plaintiff asked Karen to name every person. Oh, wait, hold on. Slide. There we go. The plaintiff asked Karen to name every person she believes is responsible for John O'Keefe's death and to list all the facts that support her claim, noting that during her 3-year criminal prosecution, where she was acquitted, and in various public media statements, Reed and her team have repeatedly pointed fingers at others. Specifically, she previously accused certain individuals of beating O'Keefe inside a home at 34 Fairview Road after a night of heavy drinking and publicly declared to the media, quote, "We know who did it." They also say that despite making these public claims and wait, hold on, that's not right. Oh, yes, it is. They say that despite making these public claims and using them as a defense in their lawsuit, Reed has refused to provide specific names or evidence under oath. And now I want to read real quickly her response because that'll just trust me, it'll make sense because they're all going to argue about it for a while. All right, so page 3. 1, 2, 3. Okay, let's share this tab. There we go. All right, let me make this a little bigger for you guys. So this is the question. Hello, Mark. Hello. Hi, happy Monday. Hope you're doing well today. Happy to see you here. So the plaintiff's question to O'Keefe was to identify each person who you claim is responsible for the death of John O'Keefe, and for each such person, state all facts forming the basis of your claim. Which I have thoughts about this, but we'll read it first. So this is her response to that question that the plaintiffs are very unhappy with. Ms. Reed objects to the interrogatory as seeking information that is irrelevant to the subject matter involved in the pending action and therefore outside the scope of discovery. Ms. Reed is not required to identify the specific persons who were responsible for Mr. O'Keefe's death. Ms. Reed also objects to this interrogatory as seeking information outside of her knowledge and possession. Ms. Reed is not an investigator or police officer and is not otherwise responsible for or skilled in determining who is at fault for a person's death. That's a very fair point, by the way. Ms. Reed further objects to this interrogatory to the extent it seeks information subject to the attorney-client privilege or work product doctrine or is posed solely for harassment and publicity purposes rather than to elicit legitimate discovery. Subject to and without waiving these objections, Ms. Reed states, excuse me, sorry guys. So Karen says, I was acquitted by a jury of all criminal charges relating to the death of John O'Keefe after a full and public trial that exposed pervasive investigative misconduct and corruption. I did not cause and am not responsible for Mr. O'Keefe's death. I did not strike Mr. O'Keefe with my car. The evidence will show that Mr. O'Keefe's wounds appear inconsistent with being hit by a vehicle and consistent with being in a physical altercation and attacked by a dog. The individuals and entities who had the responsibility to fully investigate the circumstances of Mr. Oki's death failed to adhere to their duties and instead ignored, destroyed, and failed to gather or investigate highly relevant evidence in and around the house at 34 Fairview after Mr. Keefe's body was discovered, which is true. I mean, the investigation is so bad. And I feel so well, hold on, let me finish reading this. They did so because of personal connections between the lead investigator and individuals within that house, as well as the occupant's connection to various local, state, and federal law enforcement agencies. The individuals in the house that night engaged in a concerted effort to direct the investigators' attention away from themselves and towards me instead. Because of the destruction and concealment of key evidence, the truth about what happened to Mr. O'Keefe has been deliberately obscured. What remains undisputed is that I play no part in causing, participating in, or contributing to his death in any way. So that is her answer that they're going to be arguing about for the next few minutes. Just that way we know exactly what was said about that. All right, go back over here to this tab here. Nagla says, I sort of get the family's point. If it wasn't you and you say you know who did it, tell me. Kind of like the Goldmans versus OJ. Yeah, I mean, that's what I was going to say is I do feel incredibly sorry for the O'Keefe family. Because to have all of this happen for somebody that you lost is it must be devastating. And they do deserve answers. Absolutely. However, the investigation is unbelievably bad. It's unbelievably bad. And I know that they want to put the blame on Karen and whatnot. But I am surprised. I am thoroughly surprised that they are suing Karen and not MSP and Karen. Because I think they have a better shot at that. So it does surprise me, but they wanna they wanna they believe that Karen did it all, so therefore they have no reason to sue the police. But it's just not how investigations are done or should be done. And I do feel very, very bad for them in all of this. So I can believe both things to be true. I can feel bad for them, and I can also think that Karen didn't do it. It's a mess, and it's so sad. Um, the memes are doing well. I'm glad. I'm glad. Or the memes, the mimes. Oh my goodness. See. She's repeatedly said it out loud. Who did it? They know. They just want her to put it in court documents. Yes, that's also true as well. They want them to name names, even though we all know the names. But I then, you know, she doesn't have these answers because she's not the investigators. But anyway, so they go back to arguing this. Okay, so we read a response. So the plaintiff argues that Karen's response is an invasive non answer that leaves out crucial details such as who committed the acts, when they happened, and who had firsthand information to prove it. They are asking the court to step in and order a complete, honest answer, which again, though, would all be speculation because there was a lot of evidence that wasn't collected or destroyed. So I still don't quite understand what they're asking to do, but uh, legally, legally meme is something that will be launching soon. So thank you for the physics shout out. You're welcome. That's a bricks and minifigs joke for those of you that don't know that reference or haven't been following us as which we'll be back to next week with the body cam footage. So we've been working on that as well behind the scenes, always busy doing something around here. So they argue that because Karen Reed formally chose to blame others for John O'Keefe's death as a major part of her defense, she cannot just make that claim without backing it up. And fairness and court rules dictate that she must share whatever specific information she has. She cannot publicly tell the media, we know who did it, and then refuse to name those people or provide facts when asked under oath in a lawsuit. Then they say that Karen Reed has the burden of proving that someone else killed John O'Keefe. In a lawsuit, all right, if a defendant argues that they shouldn't be held responsible because a third party actually caused the damage, the law considers this an affirmative defense, which is pretty much the same defense she put on for her trial as well. Because Karen, well, they didn't quite do that though in her trial, just to be clear. They went more so for the second trial, they went more so into how shitty of an investigation and disproving their experts. That was more their tactic than this uh, conspiracy of the people at the house that night, which I believe they did more in the first trial. They implied it in the second one, but their defense was more honed in. But it was certainly stuff they brought up for sure. Hi, Savage. Um, you are not qualified to say that you did not murder, death, kill someone. It makes sense. I mean, know, not guilty was definitely the correct verdict, but it must be frustrating for the family. Yeah, absolutely. Now, for the other people involved in the case, they've kind of, in my opinion, have done no favors for themselves at all. Um, but as for the family, I mean, it's just, it's unfortunate, you know. If you need access to any of the American Fork original dump, I have it behind a gateway at Archive Legally Mind that I can give you access if I need to, just in case. Oh, thank you, Mark. Um, I'll have to ask because I have somebody on my team working on it. So maybe um that would be awesome because I know we were trying to do the BAM videos from the BAM map, but unfortunately, those are not conducive for a streamer to play them because I couldn't figure out how to make them bigger or just do one at a time. It was very confusing. So we were working on getting the unredacted, but redacted for the right reasons ones. And I know that they've been working on it, but I don't know how hard they are. But I will definitely keep that in mind. Thank you. Because it's a mess. Talk about some more corruption, y'all. Wait till you see the American Fork Police Department. Holy shit balls. All right. So where are we here? Okay, so they said she is the burden, right? Because Karen is introducing a brand new theory, specifically alleging that people inside the house party at 34 Fairview beat John O'Keefe. The law places the burden of proof on her. This means it is her job to prove the theory is true at trial. The plaintiff doesn't have to disprove it for her, which I do think that they would have to bring in many of the same experts the defense had in her criminal trial um, on the ARCA guys. I mean, they were pretty good. So I imagine we're going to see some of the same witnesses as before in her criminal trial there. Court rules state that lawyers can only raise a defense if they have a genuine factual reason to believe it is true. The plaintiff argues that Reed either has real facts, which she is illegally hiding, or she is making the claim in bad faith just to cause delays. But how is that not? It feels to me like they're saying, hey, you better have direct evidence of this, when really it's going to be, circumstantial because there is a lot of stuff that didn't happen in the investigation. So it's kind of like, wait a second, isn't a lot of cases just circumstantial? But they're like, no, we want definitive proof of this if you're going to say it. It's like, well, no, it's a culmination of many things. Um, keep always complaining about Big Brother. It's fair. That's fair. So then they want the factual basis for Reed's affirmative defense is discoverable. So the legal process has a phase called discovery. That's when each side gives each other, all of their documents, recordings, all of that sort of stuff. Um, so that way the trial is a fair contest instead of a guessing game to the best of their abilities. Because Reed blamed others, the plaintiff has every right to ask for the facts supporting that blame. Karen claims she didn't have to answer because of attorney-client privilege, and the plaintiff explains that while her private conversations with her lawyer are secret, the raw facts about the case are not protected and must be shared. So, okay. They also say that Reed's answer to their interrogatory is unresponsive, evasive, and disregards our rules of discovery. The specific court rules, Rule 30A, state that when a party is asked to explain a defense, they must provide a detailed summary. This summary must name the people involved, explain exactly what they did wrong, and list the witnesses who have firsthand knowledge. I don't really know, though, how they were expecting this right away when they haven't done any depositions at this point in time, but okay. Let's say the plaintiffs point out that Karen's actual answer does none of this. She hints at a fight and a dog attack and complains that the police covered up evidence, but she never names a single culprit or a single witness to back it up. The plaintiff argues that Karen is trying to have it both ways, winning public sympathy by claiming she knows who the real killers are, while keeping the plaintiff completely in the dark until the trial. But you're not in the dark, though. There's two very public trials. Like, okay. The plaintiff asked the judge to step in and force her to either give real, detailed answers or admit under oath that she has no evidence. Okay. It seems a little early for all of that, but okay. So then, next on the same day, because a lot of things are filed at the same time, Karen now files her opposition to all the shit that the plaintiffs just said. All right. So Karen's lawyers argue that this motion from the plaintiff is pointless, or our favorite word at Couch Court with Llama, moot, because she has already voluntarily provided a new, more detailed supplemental answer that directly answers their question. In her sworn answers, Karen completely denies causing O'Keefe's death or hitting him with her car. She believes he was beaten inside the house and died from those injuries. She cannot name the exact individual responsible because she claims a massive cover up occurred, which includes, in case you're not familiar with the trial, because you didn't watch it, and that's okay, destroyed evidence. Oh, why is it like that? Ew, that's okay. Destroyed, I did my best. Multiple people who were inside the house that night allegedly destroyed their cell phones and SIM cards after finding out the court might order them to be inspected, because that was cute, wasn't it? Again, these are mostly police officers or law enforcement of some kind. And they throw away their phones. Higgins drives to an Air Force base or military base. I don't think we know what kind of base it was, or at least I don't remember. Anyway, he drives to a military base, takes apart his whole phone, throws it in two dumpsters, and says, "Oh, I don't know. That's just what I do. I got a new phone, so that's what I do." That's what he said to court, which is wild. And he said it was because he was on a case and somebody had the number and was like harassing him or something, which also doesn't make a lot of sense. You're an ATF agent, but okay. Shenanigans afoot is all I'm saying. That's it. That's the thing too about um all sides of this is nobody's made the trial. I have never seen so many witnesses of all kinds. All kinds. It didn't matter where they were from. All of them seemed to be somewhat sketchy and evasive, and it was weird. I've watched a lot of trials, and I've never even seen like EMTs be that way. It's bizarre to me, but okay. So she's saying, hey, they destroyed a bunch of their shit. before even the state got a hold of it. She also brings up home changes. Why is it like that? It wasn't like that when I made it. Oh, well, it's fine. The homeowners allegedly got rid of their family dog, Chloe. Justice for Chloe. Where did Chloe go? Noting O'Keefe had wounds resembling dog bites and remodeled and sold the house shortly after the death. Hmm, very suspicious, as I said. Poor Chloe. Oh, Chloe was a German Shepherd. I don't think she was a retired dog, police dog. Was she trying to be one, but then didn't make it? I forget. But justice for Chloe, ruining her reputation. And then police misconduct. Karen claims the lead investigator, Michael Proctor, framed her by planting broken glass on her car bumper and scattering pieces of her car's broken taillight around the area where O'Keefe's body was found. She claims investigators deliberately ignored the house occupants due to personal and professional connections. And I'm going to say that's exactly what happened. I mean, if anybody else had lived in that house besides another that weren't law enforcement, you would have absolutely been taken to the police station. It was, again, wild. In my opinion, of all her cases, Karen's civil lawsuit against the Massachusetts State Police and the Canton Police Department are is a definite win. I would think between the two, because yikes. So Karen then asked the judge to throw out the plaintiff's motion based on several points. Karen, the issue is resolved. All right. Karen has stated under oath that she believes someone inside the house is responsible, but that the destruction of evidence makes it impossible to pinpoint one specific person. Her lawyers argue she cannot be forced to give information she does not have. She is not Sherlock Holmes at all. And if two different law enforcement agencies botched this, that then a certain FBI agency had to come in and do their own investigation and basically determined that that's not what happened. The events of that night don't make sense. I mean, I don't know why I should all be on her, but okay. Okay. Violation of court courtesy. The court rules require lawyers to talk to each other to try to resolve differences before involving a judge. Karen's team says they tried multiple times to ask the plaintiffs what was missing from the new answer, but the plaintiffs refused to talk and insisted on taking it to the judge anyway. Hmm, not cooperating. A publicity stunt. Reed's team claims the plaintiffs are keeping this resolved issue alive purely to broadcast a false narrative to the media and the public, which is interesting because they accuse her of the same, but both things are true, in my opinion, but okay. Wrong timing. The plaintiffs argue that Karen hasn't proven her defense yet, but Karen's team points out that the lawsuit is in its very early stages. No documents have been shared yet, and no official depositions have taken place. If the plaintiffs want more details, they have the right to question her in a deposition later. Now, there are some lawyer emails attached to this, but I didn't get around to redacting everybody's stuff. So while I'm pulling up the emails, I'm not going to put them on screen, even though they're all lawyer emails and they're all public. If you want to be crazy, you can find it yourself. So I'll just read them to you. But while I'm doing that, make sure you hit the like button if you haven't yet. Please and thank you. Lets everybody know that we're live, puts us in the algorithm, all those funsy things. While I pull this up, and what page were they on? 17 through 23. Okay. You sent me an email, so you have my. Oh, thank you so much, Mark. I very much appreciate that. Thank you. Yeah, because that's our big next tackle with the BAM situation is we're going to focus on the police aspect next because, as you know, Mark, holy crap balls, yikes. And I think I don't want to say that they're as bad as what happened in Massachusetts, but it just kind of shows that like there are levels of corruption like everywhere. Not saying everyone is corrupt, but there's a lot that are. Um, and how it can be damaging to other cases. So I'm excited to talk about that next because it is unbelievable. Yes, thank you so much. I appreciate that. All right, so let's scroll down here because they always do the emails from bottom up. So let's see. The first one comes Tuesday, December 2nd. This was filed, we're in 12/15. All right, so this is just a few days before on December 2nd from the plaintiff's side to all the attorneys. There's so many, there's so many email addresses because there's so many attorneys. So the subject is plaintiff's motion to compel. Counsel, good afternoon. So this is plaintiff sending it to Karen Reed and friends. Counsel, good afternoon. Please attached, please find the following documents. Plaintiff's motion to compel further answers to interrogatories, which we just read, and the memorandum in support for further answers. We just read both of those. Pursuant to the applicable rules, our court will await your responses within the prescribed 10 days before filing these matters with the court. Best regards, plaintiffs. All right. So then that was what? December 2nd. So then on December 9th, Tuesday, December 9th, Karen Reed's team responds back. Hi, Mark. In response to your motion to compel and in order to resolve this dispute without the need for court intervention, Ms. Reed agrees to supplement her answer to plaintiff's interrogatory. The supplemental answer is attached. Please confirm the plaintiffs withdraw their motion pursuant to Rule 9A now that it is moot. All right. So she gave one answer and now she's went back in and gave what they wanted to the best of her knowledge, which is what we read, by the way. And then the next day on December 10th, the plaintiff's message Karen's team back. Aaron, thank you for your efforts to resolve the dispute. Unfortunately, plaintiff does not believe the proposed supplement answer satisfies the concerns raised in our motion. Under the circumstance, we do not intend to withdraw the motion and do not agree that it is moot given your supplemental answer. Very truly yours, Mark Diller. Which what a weird way to sign things. I mean, I enjoy the ways people sign off on things. But that one's just funny. And it's in like fancy cursive. I can't show you yet because I didn't redact it. But all right. So December 10th, later that day, Karen's Reed responds back to the plaintiff's Mark. Your notion expressly seeks to compel Ms. Reed to supplement her initial answer. She's now done that. The motion is moot, even if you think the supplemental answer is also insufficient for some reason. More specifically, your motion claims that Ms. Reed's initial answer was flawed because it was evasive and didn't identify the person she claims is responsible for Mr. O'Keefe's death. To address this concern, Ms. Reed has now stated under oath that based on the information and evidence available to me, I believe that one or more occupants of the house at 34 Fairview Road during the early morning hours caused his death. However, as a result, that we already read that part. This directly answers the question. The person she claims is responsible is someone within the house, but she cannot identify which one at this time. Obviously, Ms. Reed intends to uncover in discovery whatever evidence exists to identify who that person is. And if she or any other party is able to do so, she will gladly further supplement her responses. But as of today, she has directly answered your question. If you believe that the supplemental answer is also insufficient, you need to confer with us, explain why, and if necessary, file a motion that explains why the supplemental answer, as opposed to the shorter initial answer, violates the rules. Lots of rules in civil cases, so many rules. Filing a motion that only addresses a stale earlier discovery response would be a waste of the court's and the party's time and resources. Please let me know if you will reconsider. If not, we will serve you with an opposition by Friday. Please let me know when you are available to confer. So they're like, we gave you a new one, bro. Like, what's your problem? The next day, plaintiffs, Mark Diller responds back, Aaron, we convened a 9C on the record in front of the court last month. This was a briefing schedule. We complied. We respectfully disagree with your analysis below. We do appreciate that you can and will make such argument to the court. We can still get along, but agree to disagree about certain matters, which is very funny because I love passive aggressive lawyers speak like, well, you know what? You're fucking wrong, but we'll talk about it at court. It's fine. Oh, I love it. Mark says the BAMAP and Legally Mime are the only websites you need for the case. Excellent. There's so many. I mean, so many people are doing so much good work for that uh, case. It's hard to like consolidate it all, but thank you. I don't think I've been to Legally Mime. Maybe I have. It might be on my list of places that people have told me about. I know. I think I have been there. Anyway, before I get distracted again. So those are their emails back and forth. Oh wait, no, there's one more. Oh no, there's a few more. I lied. So uh the next day, Aaron gets back on December 11th. Mark, just to be clear, are you refusing to confer with us pursuant to Rule 9C and explain your concerns with the supplemental answer to interrogatory that we served on Tuesday? Thanks, Aaron. Well, Mark writes back. We have conferred about it. We provided you a detailed motion. You believe the addition of 4 sentences addresses these concerns. The court will need to help us resolve this dispute. Very truly, Mark Diller. Lawyer emails are funny, which, by the way, we get a lot of lawyer emails of them going back and forth. Just prepare yourself. Make sure you visit the dossier and partners page when you make, you know what? I'm going to type in Legally Mine right now so I don't forget about this later. Because that happens. And that way, when I'm done here, I'll be like, oh, yeah, I got to do that. So thank you. No, you're Mark with a K. Plaintiff attorney is Mark with a C. I don't know if there's a difference between Marks with a K or Mark with a C. You know, some names where they're just spelled different, like Stevens with a PH, usually different than Stevens with a V, in my experience. Is there a difference? Mark with a K about Marks with a C? All right, so those are the lawyers back and forth there. Ah, yes. Yes, the difference between Eric with a K and Eric with a C. I have a thing with names, I think. Right. Love that. All right. So, next topic we have is the plaintiff's reply to Karen's opposition to their uh, motion to compel further answers. So they come back and they say that Karen's new answer to their question is still not good enough under the court rules. They argue she is still making it vague. She's still making vague blanket statements without actually sharing the specific facts, documents, or names of people who give her this information. This seems very, to me, I don't know how normal this is in civil cases because I've never covered that many until recently. And now we're just covering civil cases out the wazoo. But I feel like they're being a little ridiculous at this point. Like, okay, don't you have a lot of stuff you need to go through right now? But I don't know. They point out that Karen and her team have spoken freely to the media and made public claims about having evidence that O'Keefe was killed inside the house. The family emphasizes that they are not part of the criminal case and did not have a head start in gathering evidence like Reed did. What do you mean? What do you mean you didn't have a head start? I don't understand. You filed this in 2024 in between the two separate trials. Or are they saying because she got discovery from the very beginning? Oh, that could be true. That's true. Unfortunately, victims' families do not get those sorts of things. So, okay. The family emphasizes, oh, I'm sorry, I did that. They want her to provide these details under oath so they can properly prepare their civil case and seek justice. The plaintiffs are asking the judge to grant their motion and order Karen Reed to provide a complete under oath answer detailing the exact facts behind her defense. So there's that. Okay. Are they done arguing about it? Probably not. The answer is no. No, they're not. So then the judge comes in, Judge Gilday, right? Yes, Judge Gilday comes in on December 17th with an order regarding motions to compel and a hearing. All right. So he has three things set before him in this order. Okay. Like I put the little pictures to know who's blaming what. I told you it's very messy. So, several motions to compel are before the judge, asking him to force a party or witness to hand over specific information and documents, right? They got Karen wants Michael Proctor to hand over documents and stuff. Then we have Karen wants to force the Norfolk District Attorney's Office to hand over data and stuff. And then we have the plaintiffs want to force Karen to give better, more complete answers to their written questions. So, a lot that the judge needs to decide here. So, does he decide anything? Well, let's see. Um, his decisions. Why? Oh man, that's weird that it keeps doing that. Sorry, I just get neurotic about it. Anyway, so the judge's decision. He requests for an in-person. Oh, I'm sorry. There was a request for an in-person hearing, which was denied. Um, the attorneys asked to switch the upcoming meeting from a Zoom call to an in-person hearing, arguing that it would be easier to handle the complicated arguments face to face. The judge denied this, stating that he is capable of handling the virtual meeting, which I think is, I don't know. I mean, there are a lot of sides to this civil suit. Zoom calls are, they leave a lot to be desired. Um, but if everybody's wanting to meet in person, then I don't really see what the big deal is. I understand everybody can't be available at all times, but like, okay. So he's like, nope, no Zoom calls, or we're only doing Zoom calls. I'm sorry. Then the attorneys are criticized for not cooperating. He's very upset about that. Oh, there was more. Sorry. There we go. So he criticizes the attorneys on both sides for not trying hard enough to talk to each other and narrow down what they exactly disagree on before running to court. So he had to use his dad voice, stop the games. He specifically called out the plaintiff's lawyers for an unwillingness to compromise and called Karen Reed's lawyers disingenuous for pretending they didn't understand what the plaintiffs were complaining about. So he's not a big fan of how things are going. But okay. I know, right? He's like, no, stop the games. And then they were supposed, because the lawyers have not made enough effort to work things out together, the judge postponed the Zoom hearing from December 19th to January 6th. It was kind of like, don't make me turn this car around. He also, in this order, lets the lawyers know he has expectations of them. Very different judge compared to the previous one that was on this, but he was like, this is what I expect of you guys. All right, to talk and compromise. The judge is using this extra time between the hearings to force the lawyers to talk and narrow down their disagreements so they're not in court all day. Create arguments or create agreements. Sorry. The lawyers must try to agree on a protective order, rules to keep confidential information private, for the documents coming from the Norfolk District Attorney's Office, as well as an official schedule for the rest of the information sharing process, which they put on the tickler, which they are not good at adhering to any of those dates. File updates. If they want to submit extra paperwork to explain their arguments, they must do so by January 2nd. The judge specifically requested that Karen's team address concerns raised by the district attorney's office, such as claims that her requests are too broad, ask for unrelated personal information, or violate privacy criminal court orders regarding cell phone data. So he is very annoyed that it seems like, in my opinion, he is very annoyed that they're not agreeing on anything and filing all of this paperwork and bothering him, which, I mean, I kind of thought that was part of his job, but okay. Again, I don't know much about civil trials, so this judge makes his own problems. Why aren't you guys agreeing on things? Sir, have you met lawyers? Civil lawyers? If there's anything I've learned, there is an egregious amount of paperwork and back and forths of just wasting time in civil cases, but apparently that's how it works. So those were his orders about things. Then on December 26, 2025, Michael Proctor's attorneys, Jason Crotty, Matthew Hamill, Thomas DeGangi, I don't know, enter on his behalf. That's right. There's his dream team of lawyers there. So they make an appearance. Then on December 29th, 2025, Karen files her memorandum of law in support of motion to compel Sergeant Sean Good to produce documents in response to subpoena. And yes, I chose that picture of Good for a reason. um, so Karen asked the judge to compel Sergeant Sean Good of the Canton Police Department to produce all documents in his possession, custody, or control who they subpoenaed in November 2025. And he has yet to respond. What are the odds? Another law enforcement person being like, no, I'm just not going to do that. Why would Sergeant Sean Good want to do that? I think we know. Sergeant Good received the 911 call regarding John's death, was one of the first officers to respond to the scene at 34 Fairview, and had been at the Canton Police Station when one of the occupants of the house, federal agent Brian Higgins, visited earlier that morning. Now, Sergeant Good was recently placed on administrative leave while the Canton Police Department conducts an investigation into his conduct, which public information suggests includes his communications with disgraced former trooper Michael Proctor. No. They want documents relating to Karen Reed, O'Keefe's death, Sergeant Good's leave, Proctor, and all other relevant topics because it's a mess over there. So finally, on December 31st, 2025, why is it delayed like that? Oh, did I go the wrong way? Oh, no, there we go. It's supposed to say the 31st. Oh, well. This is December 31st. I'm a one-woman show over here. Slideshow, script, everything. Let's see. All right. It's a Monday. It's fine. It is fine. All right. So the plaintiff files a motion to continue motion hearing to compel as to plaintiff's motion to compel. Here's what's going on. All right. The court hearing was originally set for January 6th, as the judge had told us, because the plaintiffs wanted to force Karen to give better answers to their question. However, since filing that request, the two sides did talk it out. So maybe the judge's instructions were, worked. And the plaintiffs sent a new question for Reed to answer. They want to delay the hearing so the plaintiffs have time to review her answer. This delay only affects this specific issue, but not the other separate requests scheduled for that day, such as Karen's attempt to force the NDAO and Michael Proctor to turn over documents. And this was granted by the judge. So they don't have to come on the 6th because they're working this out, but there's still other stuff that is on the table. Peggy looks so Peggy in that picture. Yeah, I also try to pick pictures of them from the trials so people like notice them more. But there was a lot of Peggy that were either she was in grief, and I didn't find that to be very appropriate, or there was like a bunch of people behind her and I couldn't get rid of them. So I managed to find one. And the same with uh, John's dad, John the second. Those were hard to get. There's people all behind them. All right. So this moves us to 2026. And on that note, I need to do a quick potty and coffee break. So you guys get a meme video for a little while, just a few minutes, and I'll be back as soon as I can. It usually takes me about like 3 minutes, so it won't be long. But I need those things to continue on for what we're about to cover in 2026. So we haven't done one of these videos for a while. So let me pick out one there. Let's do number 7. Lucky number 7. All right. So go to the bathroom yourself, get more coffee, get snacks, get whatever you need to. I will be back in just a few minutes, friends. Okay. All right. Back, friends. Thank you for letting me take that little break. I hope you enjoyed the dance party. Maybe some of the memes in there you found relatable. I don't know. Um, I have a bad habit of saving memes to my phone to send to people that I never do. So I've decided to use them in making my little break videos for when it's just me on here. That coffee is so delicious. Hi, Lainey. Did you come just in time for the music? I know you love the dance party. Hope you're doing well, babe. Happy to see you here today. All right. So we just finished up 2025 of this wrongful death trial or lawsuit. And good. It gets I'm glad you think it's fun. It gets everybody up and moving a little bit. And just take a quick little break. Um, I looked over for 2 seconds and the meme was about dicks hitting me in the face. Well, it is Couch Court with Llama, so that's pretty on brand. Pretty on brand over here. All right, so let's get into 2026 of this year because things really start happening rather quickly in 2026. The rest, the last few years, there was the 2 trials, and it's just back and forth. And 2026 is things have really started popping up, and I believe, well, it's also because they're supposed to be going to trial next year. Their pretrial conference is scheduled for February, I want to say, of 2027. And then a judgment is due by like 8/29, 27. So probably in the spring, beginning summer, we might have the trial. So things have started escalating here in all of these. So you're in a hotel. Good. I'm glad you are entertained. Are you not entertained? Sorry, I had to do a 300 reference. Do I even internet if I don't? Come on. All right, so let's get into it. So first up, we have January 5th, 2026. And we have defendant, other interested party, Karen Reed, Michael Proctor's joint motion to continue to reschedule the event on the 6th, right? So the plaintiffs and Karen was already granted. They don't have to argue. They're working stuff out on the side. Well, this is regarding Laura, wrong one, Karen and Michael Proctor. So since the request was first filed, the lawyers on for both sides have been talking and cooperating. Again, maybe the judge did make a dent. I don't know. Michael Proctor has already started handing over the requested documents, stating that he is only holding back information that is legally protected by lawyer-client confidentiality or marital privilege. Maybe, but I don't know. Oh, yeah. You like that, Lainey? I chose very specific screen captures, photos of some of these people. Oh, because he's so cringy. Like, yeah, buddy, you did bad things, bad things. So, I always like to find fun where I can. Because they are working things out on their own, they want the judge to put the hearing on hold. Once Proctor finishes sending over all the documents, Karen will decide if she can cancel her request for court intervention entirely. So they're like, we don't need to go in front of you, judge, on the 6th. We're working it out. We just need more time. Totally normal. Then also on the same day is filed this is for the Norfolk County District Attorney's Office, them and Karen. Again, joint motion to continue for the 6th hearing because both sides are asking the judge to postpone. That was set to address the dispute where Karen was trying to compel the NDAO to hand over certain documents. Both sides have been talking and came up with a protocol to settle their disagreement over the documents without needing the judge to decide for them. They need more time to finalize the agreement with everyone else involved in the lawsuit, so they want to schedule hearing. They want the scheduled hearing on pause. Then we got another interested party, Michael Proctor's statement in support of the Norfolk County District's opportunity. Oh, sorry. The Norfolk County District Attorney's Office's opposition to defendant Karen Reed's motion to compel production of data. So this is not related to the hearing. Okay. So he is asking the judge to reject a subpoena from Karen's legal team to hand over data from his personal cell phone, which I thought they were working stuff out. So I'm a little confused about this one, but okay. Her team wants access to a massive amount of personal data from Proctor's phone, including texts, chats, photos, videos, and audio files spanning multiple years. Proctor's lawyers argue that the request should be denied for several reasons. Right. The first is that they're saying it's a fishing expedition. The request is described as a random search based on a mere hunch that useful information might be found rather than a targeted request for specific evidence. Well, that's because you say all sorts of shit all the time that you shouldn't say, Proctor, but okay. She already has the relevant data. Reed's team already possesses 38,707 pages of text messages from Proctor's personal phone. Almost 39,000. 39,000. These were previously gathered during a federal investigation into the police handling of the criminal case against Reed. Proctor argues that if any text messages existed showing he was biased against her, they would have already been uncovered in those 38,707 pages. That's insane. Again, I am available to be hired to go through all of these things because I'm nosy, but also organize them. I'm free. So that's a bunch. A hunch, right? A hunch. Yes, he is a bad dude. It does. Do you think he's shamed? I don't think he is. I don't think he's shamed at all. It's hard to shame people like that. When people are filled with hate. They know no shame. All right. They also go on to say the request is too broad. The demand covers a time frame of over 13 years, stretching back to a time before Proctor was even hired as a state trooper in 2013. His lawyers estimate this includes over 100,000 items. So that's a lot. That's a lot. Should it be before he was a cop? I mean, I don't know. I don't know if that's relevant, but I could see that. They also say that it violates privacy rights because the request asks for everything on his phone. It would expose entirely private communications and photos involving his wife, children, parents, and friends, none of whom have anything to do with this lawsuit. It also seeks protected and sensitive information. The phone contains legally protected data that Proctor cannot just hand over, including private messages with his wife and lawyers, sensitive confidential details regarding other ongoing criminal investigations, and private medical records protected under the Federal Healthcare Privacy Act, HIPAA. Right. Sensitive and confidential. Right. So Proctor is asking the court to block that request because forcing him or his lawyers to sort through 13 years of private data would be an unfair, expensive, and an overwhelming burden that violates his privacy rights. So he is asking the judge to order something on that. Then on January 6th, 2026, the hearing is rescheduled since each party asked for a continuance because they're all working together. And the judge also schedules a hearing on February 3rd to discuss Karen's motion to compel Sergeant Sean Good to comply with the subpoena. Then on January 7th, the judge grants the procedure agreement between all parties and the Norfolk District Attorney's Office when turning over documents. They created like a whole system together. All parties agree this is a good way to do it. So the judge says, yep, that sounds great. If you all agree, I agree. So January 9th, 2026, attorney Jennifer Smith appears as counsel for Sergeant Sean Good. It's stupid face. Ugh, that guy. So she appears on his behalf. Then on January 28th, Karen's team files a motion to withdraw their motion to compel Sergeant Sean Good. Since he is now being represented by an attorney, they asked it be done without prejudice so they can file again if there is no cooperation. But they're trying to cooperate with his attorney to get what they need. But if that falls through, then they'll bring it back up again. So, yes, everybody be like Mark over here, Mark with a K. Good Mark. Sorry. Be sure to like, sub, and share. You know what I made for today too? Mess, because I'm never on Mondays usually. I made a banner to remind people. So double it. You got multiple accounts? Like it on all of them, please and thank you. And subscribe to all of them on all of them. Let's see. All right, so there's that. So now we finally get to watch something. We get to watch a hearing. Are you guys excited? This is now the second hearing we get to watch. Puts us in February 3rd. Hold on just a second. I gotta switch my stuff around. Switch to that account. All right. And it's a Zoom hearing, so this should be interesting. I do not know what these are about. I have not watched them. So we're going to watch them together for the first time. Let's share this tab instead. There we go. So does it have closed caption? Yes. Okay. So this hearing is from February 3rd, 2026. This is brought to you by the Trial Channel, one of my personal favorite channels. She does an amazing job. She will take out sidebars, dead air, breaks, lunch breaks, all the above, and just take that all out of the day so you get just the information from the case. Love her channel. So she has the Trial Channel, which you should absolutely subscribe to down here. It looks like this. And then she also has the Trial Files, which have more Karen Reed stuff on it. A lot of people's police interviews, which we will be watching probably after we catch up on this one before we move to the Turtle Boy one. All right, and we'll like this one. So this is about 35 minutes, and let's give it a good. This is so many lawyers. It looks like, did any of you used to watch Judge Alex Manning from Georgia? She would do her pre-trial. That one, that's Judge Alex Manning. I love her. But she would do ones where everybody was in jail already and stuff. I can't remember what that is called. Arraignments. And there would be like a million people in this Zoom room. That's what it reminds me of. All right, so let's see real quick. Let's do a who's who on the board of people. All right, so up here in the top left, it's like Hollywood Squares, is Aaron Rosenberg. He's attorney for Karen Reed. Mark Diller here, that's not a flattering still of him, plaintiff lawyer. Arthur Maravellis is Karen Reed lawyer. Damon, Karen Reed lawyer, which he looks so much different. He looks older in this video than he did when they were in court. Maybe that's why they wanted to be in person. I don't know. But so Karen Reed, Michael Bell, Karen Reed, right? Is that right? Yeah, I think so. David Hassett, I don't remember who they're for. I think one of the bars. Alexandra Beaton, I don't know. I don't remember. Charles Waters, I know he's a Karen Reed lawyer. Civil, the court's down here in the bottom right. Tamara Smith, I think she is with, hold on. I have another cheat sheet over here. Tamara Smith. Oh, wait. Tamara, wait. Oh, Alexandra Beaton, her here is with CNC Hospitality. Oh, Alexandria Beaton is, yeah, there. Hassett is the Waterfall Bar and Grill people. Okay. Tamara Smith, that's okay. So that's Bar. Dan Buck, he would be Karen, attorney, and BB Fell. She is with the plaintiffs. So that is who on these. Eventually, we'll learn all their names and who they are and who they're with. But all right, let's get into this one, shall we? I'm interested. I have no idea what they're talking about. Status conference discovery hearing. So let's go.
Civil action number 2483CV00692, Paul O'Keefe, individually and personal representative of the estate of John Joseph O'Keefe III et al. Versus CNC Hospitality LLC, doing business as C&F McCarthy's et al. Your Honor, it looks like counsel is all present on Zoom.
Okay, so who's here for the plaintiffs?
Good afternoon, Your Honor. Attorney Mark Diller, together with BB Fell and Dan Buck.
Good afternoon.
Why does he look so
And
small?
who's here for CNC?
Good afternoon, Your Honor. It looks like my co-counsel was just bumped off, but myself, Alexandra Beaton, and Tamara Holslag.
Okay.
She in the waiting room somewhere?
I just brought her back in. She was just promoted back to the panelist, Your Honor.
All right, who's here for Waterfall?
David Hassett, Your Honor, along with John Dealey.
Good
All right.
afternoon.
Good afternoon.
And who's here for Ms. Reed?
Good afternoon, Your Honor. Aaron Rosenberg, and also with me are Damon Seligson and Charles Waters from Sheehan Finney, and Arthur Maravellis and Michael Bell from Tanga Maravellis.
It's so
Good
many lawyers.
afternoon. So why don't I start with the plaintiffs? Well, first of all, as I understand it, all outstanding issues relative to subpoenas have been resolved or put on the table for now. Does anyone disagree with that?
No, that's correct, Your Honor.
Okay. So let's start with Attorney Diller. Why don't you try and address the issues I referenced in the order from January 6th about what depositions have been completed, non-party, party, as well as
Okay.
subpoenas, and what you think about adhering to the discovery deadline. So go right ahead.
Sure, Your Honor. Thank you. I can tell you that at present, no depositions have occurred. On July 24th of 2025, plaintiffs propounded
No.
extensive discovery to both the Reed team as well as to the Norfolk District Attorney's Office. Back in March of 2025,
How has there not been any depositions done? Like, that's kind of crazy. The only depositions that the plaintiffs weren't allowed to do during the trial was Karen, her mom, dad, and her sister-in-law. How have you not done any depositions for any of the bars and their employee, all this other stuff that you claimed in your initial complaint? You haven't deposed anybody? And it's 2026 at this point, February of this year? Yikes. Okay.
we had propounded extensive discovery to the bars. I can tell you that the first time that we received any document discovery, there was an attempt in November 20th of 2025 by the Reed team to turn some of that over. We then had a conversation on December 2nd again, at which time there was an attempt to turn that over. We received a document dump on December 10th of 2025 that amounted to about 990,000 pages and more than 500 hours of both audio and video.
Wow.
But it was not accessible completely. In fact, I would suggest that it was pretty much inaccessible and unusable for us at that time. We had a meet and confer with counsel for the Reed team, at which point we didn't have an agreement. We were requested to serve a motion to compel, which we did. That motion to compel was received by the Reed team on December 23rd, 2025. We've since had another meet and confer We've tried to resolve the difficulty we're having accessing and navigating the very extensive discovery in this case in order for us to dive into it and be able to narrow down the issues with which we wish to convene depositions. I can tell you that we have been cooperative with the Reed team, and they have engaged on at least 6 separate occasions, attempts since January 1st of this year to try to help us resolve the issues that we're having accessing those documents. We have a third-party vendor involved in trying to help us access them. I can share that as of this morning, we received some additional we received a load file, which was going to help us allegedly navigate those files, to which, since it was received, I haven't been able to engage with our vendor to figure out whether we can access all of it. I want to share with you that, Your Honor, we have discussed extensively with also the defendants of the bars whom we have exchanged discovery and have talked about who we will be deposing from their parties and vice versa, and who non-parties we intend to depose. But I can share with you that we would all prefer to have the benefit of being able to access and utilize all the documentation and all the discovery. One of the issues, Your Honor, is not only that it came to us in a not usable fashion at first, but it also is not indexed. And so we had 37 requests of July of 2025 with subparts identifying what the documents that we were requesting to be turned over. And at this time, we cannot match up to even determine whether or not we have received a complete production. So that is why there have not been any specific depositions that have actually occurred at this stage, but we have been very proactive and we've been very cooperative with all the parties trying to figure out how to get past identifying and accessing the documents, but we are not there yet.
Your Honor, if I could respond to some of that, if you'd like.
I don't know who that is.
That was Aaron Rosenberg on behalf of Mr. Reed.
His square lights, Your Honor.
Okay, so
it's kind of difficult to believe in this day and age that you can't produce documents in a manner that they're accessible by.
I agree, Your Honor. I agree, Your Honor, and we did produce them in a manner that was accessible from the very beginning. Let me just take you through exactly what happened here.
Okay.
Mr. Diller referred.
Hang on, Attorney Rosen. Why don't you do this? Whatever form you provided it for the plaintiffs, provide a copy to the court. And
Well, Your
we'll see
Honor,
if we can access it.
well, Your Honor, this is an ESI production of up to 1 million pages of electronic.
I understand what it is, but they can't open it. So I want to see whether the court can open it.
Your Honor, if you would,
put that on your list to produce whatever you produce to the plaintiffs to the court. So go ahead.
Well, Your Honor, I'm just telling you that you're not going to be able to open it or use it unless you have
Charles over here being like,
discovery software, which I don't believe the court has. So if you'd let me address what Mr. Diller had to say, I think that will make more sense. So first, Mr. Diller.
Hang on, Attorney Rosenberg. What would make sense to me is you telling me how the plaintiffs and any other party can receive the responses to discovery in a usable form.
He's trying to tell you.
That's what I'm trying to do, Your Honor. So it was produced in a form that can be taken and uploaded to the type of e-discovery ESI software that all the parties to this case, including the plaintiffs, are using. I've spent I've spent hours and hours on the phone with Mr. Diller's colleague, Mr. Buck, who is on the line, as well as Mr. Diller's e-discovery consultant, who last week confirmed to me in a call that they can in fact access them. The concern that Mr. Diller had raised was that he didn't understand the organization of the documents. My response to that was that that's completely fair, and I'm happy to discuss what the organization is and why he's having trouble viewing it. In that conversation with his e-discovery consultant last week, it was confirmed that there was one field of metadata that was missing that didn't allow Mr. Diller and his firm to see that organization. Today, or last night, Mr. Buck from Mr. Diller's office asked for an extra field of metadata, and we provided it within minutes. So it's not accurate to say that they can't access it. They can access it. More importantly, when we talk about organization and Mr. Diller characterizes a document dump, that's completely incorrect. The plaintiffs have asked in this case for every single piece of paper that was exchanged between the Commonwealth and Ms. Reed's defense team
Over 1 million.
in both criminal trials. That is almost 1 million pages of documents. When we first started conferring about this, I confirmed with Mr. Diller, you want every piece of paper that was exchanged, right? Because you keep referring to 1 million pages of documents, and he confirmed it. So the fact that it's 1 million pages is us complying with the document requests that the plaintiffs have served. The manner in which we produced them was so that they were organized all in separate folders by notice of discovery, which is how, as Your Honor obviously is aware, documents are produced in criminal discovery. Each said folder has an actual notice that serves as a table of contents for each of the folders, laying out exactly what is in each
That's
folder.
amazing.
So for the plaintiffs to claim that there's some dump or disorganization is frankly just not accurate. And as I said, I have bent over backwards and will continue to do so to enable the plaintiffs' ESI folks to view it in that very organized fashion. What I understand from their consultant is that they now should be able to. If they can't, by all means, I'm here and I'm willing to continue to work with them on it. So that's an important thing to note. They can access them, and we will make sure to help them as much as we can. But this is the third time this has happened in this case, Your Honor. There is no motion before you, which is why you're left to ask questions and hear me respond to these issues prior to having papers before you. We've engaged in 9C conferences for weeks, actually months, on this topic. And as of last week, had a confirmatory email with me to Mr. Diller's office where they confirmed that we're all on the same page. If they need anything else, they'll reach out. And I specifically said, if there are any more disputes about the production that you think we need to address, tell us. And we didn't. Instead, we showed up for this hearing, and Mr. Diller takes the opportunity to paint the Reed team as if we're hiding documents or not producing things or dumping documents on them. It's just not accurate, and it's not compliant with Rule 9C. And I think we need to understand that we need to adhere to those rules in this case in order for things to move forward in a substantive manner.
Anything else on that issue, Attorney Rosenberg?
No, Your Honor.
Okay. Attorney Diller,
Yes, Your Honor.
when are you going to know whether you can access what was produced?
We've already reached out to our e-vendor to see whether or not the information the link that was provided today, whether that resolves the issue. It may resolve some issues, and I want to be clear, Your Honor, that we were not suggesting that nothing was provided to us or that we couldn't access anything. What I am saying is there are 990,000 pages and over 500 hours of audio and video. And we have only begun to start receiving it in a fashion that we could actually start to get up to speed with what's contained there, in order to help us to convene depositions. I did, just to confirm that it wasn't just me, because I was concerned that it was just me, I did ask my brothers and sisters from the bars whether they also received the same request and whether they had any difficulty accessing it. And they did share with me, and I'll let them speak for themselves, that there was also issues for them accessing them. That's not to suggest that I'm not sitting here trying to paint a nefarious picture, but I am trying to show this court that we have been very proactive in trying to get up to speed on a matter that the Reed team has had 3 years of a head start, and there is very extensive discovery. And that's why we had requested that it be provided not only in a accessible and usable fashion, but also that it be indexed so that we would know whether or not there's anything missing.
So what does he even say? I mean, to me, it sounds like this doesn't even need to be talked about at all. So you're getting all this information. It's a lot. At first you couldn't access it, but now we're all working together trying to get it. Just wanted to let you know, end of story. Why are we doing this? It's been like 20 something minutes, 14 minutes. How's the judge not yelling at him for because I don't understand what he's. All right, that's a good screenshot. Oh, I should clip that later and use for my slideshow. Right? Like, what are we doing? It's weird. Like, well, sir, there's like 1 million documents and we need more time to go through everything before we do deposit. Well, no shit. I mean, I could have told you that when you filed this 2 years ago, but all right. And now you're complaining that, well, we're just now getting on. They've had 3 years to do it. Yeah, because they tried to put her in jail for life. So, yeah, but also, you know how much discovery there is in this. Don't act all shocked Pikachu about it. Oh, wait, that's the wrong screen to press play on.
Because to go through 990,000 pages and 500 plus hours and then try to figure out which requests or which documents respond to which of our requests, we're not able to competently at this time, Your Honor, come before the court or have a meaningful 9C about what is missing, if anything. No privilege logs have been provided, so I assume that they've turned over everything. But I just want to share with Your Honor, that's the predicament that we are currently facing.
Right. Okay. Cool story, bro.
Okay, let me hear from CNC, please.
Good afternoon, Your Honor. Tamara Smith for CF McCarthy's. Can you hear me? Because it does appear that my screen is frozen.
I can hear you. Thank you.
Okay, thank you, Your Honor. You know, we do not have any claims against Ms. Reed, nor does she against us. So we haven't propounded discovery to them or them to us. So we are the indirect recipient of the documents that Mr. Diller and Mr. Rosenberg have been speaking of. I guess all I can say is that I certainly agree that it is necessary for us to defend our client fully, to know what is in these documents and what is not in these documents. Certainly many of them may be completely irrelevant to my client, but I need to be able to still get through them and discern that one way or the other to best represent our client. And I can at least confirm that in our review, we have an operations manager, a paralegal, and various IT people as well that have been looking at the same 990,000 pages of documents and 518 videos. And we have had,
I mean, I'll give them this. That is so much to go through, right? Like this case, I don't know how many documents have come out just in this case that I had to sort through to even be able to tell y'all what's going on. They've had 166 different, things on the docket. 166. It took me several days. I can't imagine. I can't imagine going through 1 million. Oh gosh, what a nightmare. But hey, they knew that it was going to be like this though, but okay.
our own issues as well. So, I can expand on that if you wish, Your Honor, but I can confirm that we have some very technical folks on our end that have been trying to access the documents for the same purpose of moving this case forward. And it's been difficult. And so now we're put in the position of trying to take what has been produced and get an e-vendor involved, which is going to cost more money, of course, but we're getting an e-vendor involved just as Mr. Diller is, to try to better access these documents. And then I would just say to, from what I have been able to see with the 518 videos, they're not, as far as I can tell, categorized in any way. My operations manager has told me that we can see that there's driveways, there's ring doorbells, there's some body cams, there's cars backing up, which I can presume is Ms. Reed's. There's some audio files that sound like they're coming from dispatch, but nothing is date and time stamped. We're having a difficulty sort of trying to read through it and discern what is relevant and what is not relevant from those videos. And then with respect to the folders that I believe Mr. Rosenberg has referenced, we're having a hard time opening those as well. They seem to be either corrupted or not in a proper archive format, to the best I understand what my technical people have told me. So I can just say, Your Honor, we are having some similar difficulties that we would love to get past with the cooperation of all parties in the court.
I love Aaron's
What
face.
depositions, if any, have been noticed by CNC?
Aaron seems very annoyed. Aaron up here, Aaron Rosenberg, one of Karen's attorneys. He just seems like, what do we do? Yeah, I know it's a lot. I know. And I know we're all still trying to sort it out. So what are we even talking about here? But okay. He looks very annoyed.
We have not noticed depositions for two reasons. One, there will probably be very few from us, Your Honor. But two, we want to only notice depositions that we truly intend to take and are not duplicative of other parties. So we have talked with Mr. Diller and conferred with him on the short list of folks that we would anticipate that we would like to depose. And frankly, we've also talked to counsel for Waterfall about this. And then, of course, Mr. Diller has talked to me about some of the folks at McCarthy's that he would be looking to depose. But on both sides, it's a relatively short list, Your Honor. And as soon as we get through these documents, we are in a position to proceed with that type of discovery and with depositions.
Thank you. Why don't I hear from Waterfall, please?
Thank you, Your Honor. David Hassett. Judge, we have responded to the plaintiff's discovery, interrogatory answers, and document responses. We've also propounded discovery to the plaintiff and to the individual plaintiffs identified in the suit. That discovery is outstanding by agreement. As to the documents produced, we also have not yet commenced deposition. The documents that we have gotten through the discovery to date, we've been working through and expending efforts to get to the documents, understand the documents. We've had some challenges, but we've been trying to implement some workarounds, but that is not completed yet. And we also have a discovery e-vendor that will be assisting us in the pursuit of getting our arms around all those documents. We have been in discussions with Attorney Diller and Attorney Smith about the depositions we would be taking. There are obviously some overlap with the depositions that the Reed team would be taking and the O'Keefe team, but that the separate depositions of patrons or witnesses, we conferred about those. I agree it's a relatively short list, and the hope was for us to review the documents before starting that process.
Attorney Hassett, do the challenges you have encountered include the inability to access the documents produced?
Not all of them, Your Honor. We have been able to access documents, but we haven't been able to access all the documents. For instance, some of the folders that were described by Mr. Rosenberg and Mr. Diller, they will open up and they'll be blank, there'll be nothing in there, or they're corrupted. I believe we've had some communication with Mr.
I'm keeping my eye on Aaron Rosenberg. He is just like, oh yeah. We've already talked about this.
Rosenberg's office about some access to files in our own IT support internally. So what I would say, Your Honor, based on 990,000 pages, there is a percentage that we haven't accessed properly or completely. One thing I will also add is that there is a load file that we recently received that has metadata. It appears that will assist in terms of accessing documents or files that we've struggled with. So that's something that we intend to do next.
When did you receive that?
I think it was in the last week, Your Honor.
Okay.
Are you guys
Your Honor,
watching? Aaron,
can I just note, Your Honor, I haven't heard from either of the two bars about these issues. I'm happy to work with them, just like I've been working with Mr. Diller to have these documents, assist with whatever technical issue that they're having. I just haven't been aware of those yet. So if they reach out to me, I'm again happy to help with that. But I understand there is a lot of paper here, and there is a need for e-discovery vendors because primarily the plaintiffs have asked for all of these million pages of documents. So I understand why all of the parties are explaining the need to access things in order to go forward and proceed even further with discovery. But I just want to be clear, to the extent there's any technological issue, parties need to reach out to us and let us resolve those, which we will do.
But the common theme seems to be that they're all having some difficulty.
Yep.
Well, I agree with you based on what I just heard, Your Honor, but I'm not aware of that until just this moment. The only party I've conferred with about these issues is Mr. Diller, and we've been talking about it for, I think we'll agree we've been talking about it for a month or more. So I'm more than happy to do that, and I don't know what the issue is from the other defendant's perspective. I know from Mr. Diller's consultant what the issue is now, which I believe we've resolved, and he's said he should be able to know that shortly. So I would suggest I'm happy to speak with anyone that needs to in the next couple of days to address any technological issues that are remaining.
Is the judge going to be like, send it to me?
So Attorney Rosenberg, in November, Attorney Waters indicated that the Reed team had sent out between 10 and 12 subpoenas.
That's correct.
It appears you've resolved, at least for now, issues relative to Sergeant Good, Mr. Proctor, as well as
That is
the
not my mouth.
Norfolk County District Attorney's Office. That's 3. Who were the other parties that notices of deposition went out?
So there's only been one. There's only been one.
Well, Attorney Waters indicated between 10 and 12. I've just addressed 3 of them, so that leaves 7 to 9. So you said there's only been those 3?
No. So the question to Attorney Waters at the last hearing was subpoenas. Those were primarily document subpoenas. The deposition subpoena and the notice of deposition, which is the only deposition that's scheduled thus far in this case, is our deposition of Michael Proctor, which we've finally locked in with everyone's availability, all parties, counsel, and Mr. Proctor and his counsel's availability. And that'll be going forward in April. We have not yet scheduled other depositions, but we from the Reed side plan to do so very shortly. And as you can tell, obviously the discovery from our end is going to be primarily third-party discovery. So there will be additional depositions put on the calendar soon, as soon as we're able to coordinate schedules, which has obviously been daunting in this case.
So just so I understand, what subpoenas have been sent out?
So we've sent 2 subpoenas to Michael Proctor because there was additional information that became we became aware of. We've sent a subpoena to the town of Canton. We sent a subpoena to the Boston Police Department. We sent a subpoena to the Massachusetts State Police, sent a subpoena to Sergeant Good, as Your Honor said. We sent a subpoena to, I don't know if I said the District Attorney's Office, but both us and the plaintiff sent subpoenas to the District Attorney's Office. We sent a subpoena to Mr. Proctor's prior attorney in connection with his appeal, just relating to this one particular issue that is relevant to the District Attorney's Office subpoena. There might be 1 or 2 I'm not thinking of off the top of my head, but that's the bulk of them thus far.
When did the subpoena go to the town of Canton?
The subpoena to the town of Canton went, off the top of my head, July or August of 2025, I think.
And have you received a response?
We've received documents. We are currently discussing with their counsel additional documents that we had been under the impression they didn't have, but now I believe they may actually have. So I'm in the process of a 9C conference with their counsel to determine if they will produce these additional documents that they should produce from our perspective.
When did the subpoena to the Boston Police Department go out?
Roughly the same time. So the first subpoenas we sent all around the same time was the town of Canton, the Massachusetts State Police, Michael Proctor, and the Boston Police Department. Those were all July to August. And then, as I said, we followed up with a second subpoena to Mr. Proctor, approximately September of 2025.
Would you agree that 8 months to resolve issues from subpoenas might be a little unreasonable?
I certainly would, Your Honor, but here's what's been happening in this case. Every time we serve a deposition, we serve a subpoena, we either are ignored by the recipient of the subpoena, as happened with Sergeant Good, happened with Mr. Proctor, happened with, at first, the Boston Police Department. Then we're presented with objections and a refusal to produce documents. We try to confer. These are government entities in large part that we're discussing right now. And it takes time to even get people on the phone. We get them on the phone. There's continued refusal to produce documents. We attempt to confer as we're required to under 9C to try and get documents without burdening the court with motions to compel. We then, in some instances, for example, the district attorney's office, just as one example, they have a set of documents that were taken off of Mr. Proctor's personal cell phone and then identified by the district attorney's office in the Commonwealth, documents that may be evidence of bias. They did that pursuant to a court order in other criminal cases. They then returned that phone to Mr. Proctor. We tried to get the phone and the same data from Mr. Proctor pursuant to subpoena because the district attorney's office told us they wouldn't give it to us because it had to come from him directly. As it turns out, that phone, after it was provided back to Mr. Proctor from the district attorney's office, in the short period of time between that and when he hired his present counsel, he apparently lost that phone. So now we can't obtain those documents from Mr.
He lost his phone. Michael Proctor lost his phone. And what are the odds? What are the odds, friends, that would have happened? Like, bro, everybody's already got your stuff off that phone. There was no point in losing it, but what a coincidence. Am I right? Fucking Proctor. He's the worst. Also, I feel like the judge is getting on their case about all these subpoenas. Is the million documents they handed over to the plaintiffs here not including all of those? Or are they? I don't know. But I feel like the judge is being like, so, like, you've subpoenaed people. Why is this taking so long? And everybody else hasn't subpoenaed nobody or deposed anybody. They've done nothing. It's weird. I don't like it. It's in the park with Rebel Wilson's last ones. What are the odds? Oh, my goodness. Crazy. Scandalous. Everybody's always so scandalous.
Mr. Proctor. So we had to go back to the district attorney's office and tell the district attorney's office we need it from them. I then engaged for 2.5 months negotiating an agreement with the district attorney's office, which would only give us these relevant documents, despite the civil rules, would only give them to us with onerous restrictions that are unusual if never occur in civil cases like this. But we agreed to that because we need to get the documents. So I 100% agree with you. When we've sent out subpoenas, we have not gotten the responses that we should have gotten under the rules and the law. But we've had to put in a lot of extra time and effort and resources to getting these entities to produce documents. The state police still haven't produced documents. I was under the impression they'd been reviewing them for months. Just found out from their counsel that they had made little to no progress, and I needed to again threaten a motion to compel in order for them to agree to produce to do what they have to do. So I agree with you, Your Honor. We shouldn't have to wait that long.
But here we are in February and we're not any further along. I detect a little frustration from you, Attorney Rosenberg, but why don't you utilize the court to maybe relieve that frustration? If you have issues that you need to bring in front of the court as far as a motion to compel, let's get them filed. This case.
So, can I just be clear?
Let's start moving along.
Well, I need to be clear with Your Honor, and I'm hearing you don't want us to confer with these parties and continue to drag out those conversations. The rules, I believe, would require me to do that, and I can't just come into court asking for a motion. But if you'd prefer us to handle it this way when we get non-compliance from a subpoena recipient, I'm happy to do that. I just am sensitive to the requirements of 9C.
I'm not suggesting you ignore any of the rules. I'm suggesting you avail yourself of the opportunity to use them.
But it's so funny because in his December ruling, when he told all the lawyers they need to cooperate and, you know, don't bring all these issues to the court. And now he's like, how about, why are you not telling the court about this? Ugh. Yikes. Okay. Oh, Rosenberg is so just irritated. He is frustrated. He's frustrated with you. Because you're making it seem like it's his fault that the state in different capacities don't want to cooperate, which, I mean, is certainly frustrating. And, you know, if they want to sit there and say, oh, well, Karen Reed had 3 years to sort all this, so did all these other people. So why is it taking so long for the town account and the Massachusetts State Police, all these different ones? Why is it taking them so long? I know why. I know why. Because there is stuff they don't want out there at all. So, right? Right, Seichi? Like, what? What are you saying, sir? Like, okay.
And I'm simply
Oops, sorry.
suggesting that the length of time that it has taken to resolve issues that shouldn't really be issues appears to me to be excessive. So we have to figure out a way to bring them to a head.
Well, I agree with you, Your Honor. It's just, it's excessive from the recipients of the subpoenas. We're certainly not delaying anything. We've been demanding documents since July, and we've been out there taking discovery and trying to move the case along, which is what we intend to continue to do. So as soon as I have a situation where the recipient of a subpoena is not engaging in good faith conference under 9C, we've been filing motions, and we've had, I believe, 3 or 4 before, Your Honor. Then the parties who have received the subpoenas seem to all of a sudden be more willing to comply just before we have hearings with the court. And so we are using those tools and we'll continue to do so.
That is absolutely the pattern. I mean, that's absolutely the pattern in the whole docket. You guys, as we've been reading together, they file this and then it's like, oh, you know what? We're going to work things out. And then they go back and do nothing.
Anything else?
Not for me, Your Honor.
Okay, so why don't we all plan to get together next Thursday at 4 o'clock in the same fashion? And Attorney Diller can report on his success or lack of success in seeking to access the documents. And it'll give you and Attorney Diller a further opportunity to talk about his concerns about categorization or identification of the documents that are produced. And then I'd ask
full use of time.
All the parties to submit at this point in time the intended depositions. And I understand that may change, but I want to know who people intend on deposing. Is there anyone that can't make it next Thursday at 4 o'clock?
You're muted, Water.
Hearing no response, we'll see everyone next Thursday. Thanks very much.
Your Honor, I have a question though about the request for the intended depositions. Are you looking for that to be a formal written disclosure, or is that something that we could show you in camera so as not to make public all the parties that we intend to depose.
You can share it to me in whatever fashion you want to.
Okay, thank you, Your Honor.
All right? Anyone else have any questions? Okay, thanks very much. We'll see everyone next Thursday.
I'm not sure if Aaron
Thank you.
has-
For the
Thank you.
record, this matter is continued to February 12th, 2026 at 4 p.m. for further status, and that hearing will be held via Zoom.
And Attorney Rosenberg, still, because I want to have a clear record here, please, as I indicated earlier, provide the court with a copy of whatever you produced to Attorney Diller.
So he's
Okay,
on
that'll
top-
actually, it'll come from Mr. Maravellis and Mr. Bell, my co-counsel. The production
Okay.
came from their office.
All right. Thank you.
So he's
Your Honor,
Thank you.
Your Honor,
Yes, sir.
with respect to production, who would you like me to coordinate with? Because our office will need to coordinate with somebody from the court with respect to e-discovery. We cannot just send you an email. It's a much more complex process that we've been involved in. We have an e-discovery vendor, and we would need somebody on the court side to have it, to be able to receive it. Otherwise, we can't just, you will not be able to receive it
we can't just email it
just
to you.
via email. You'll need some type of
It's a million
its
things.
technical capabilities to receive the actual documents. So
If
we're happy
you
to coordinate with somebody with the court if there's somebody you'd like to put us in touch with.
You can start with Assistant Clerk Donovan.
Okay.
Okay?
Thank you, Your Honor.
Thank
Thank you,
you.
Your Honor.
Thank you.
Thank you all.
Rosenberg's gonna go have a a beer after that hearing. Good God. Oh God, that was annoying. Is anybody else annoyed about it? Because I am. One, he lets Diller ramble on for how long about these damn files, which I don't understand. But now the judge still wants them sent to him to see if he can access them, as though he's implying that like these are issues that I've heard of several other times in trials that we've watched or covered. I mean, that's just how technology goes, right? Sometimes it works, sometimes it doesn't. It sounds like they were all working out, but Diller wants to throw Rosenberg off the bus. Then the other two defendants, the bars, were like, we're having the same problems. And Rosenberg's like, what? How come y'all aren't telling me about this? We're happy to do it. And then the court wants their own copy. And they have tried to explain to this judge about how impossible or difficult, not impossible, difficult it is to get it to the court. But for some reason, he needs to try it himself. And then he's on Rosenberg's ass that other people aren't cooperating with their subpoenas. Like, really? But it's fine for everybody else here who, by the way, could work on things while Karen's team was busy with the criminal trial, and they haven't done much of anything. Interesting. Isn't the burden supposed to be on the plaintiffs for all this? But okay. Yikes. All right, well, that makes sense. That's starting to make some comments I've heard and seen make a little bit more sense because yikes. So we're going to keep going on. I have to be done before 1 because Sarah's midday missing today. So say cheese, this judge will never be able to access the files. I mean, come on. And I like how he's like, nope, I think I got it. I'm going to solve this. Are you, sir? You're not even understanding what the lawyers are telling you, though. But sure. He's like, I got an IT guy, Derek. I don't know if he has a guy named Derek, but that's what we're going to name him. Anyway, back to our timeline. So that was February 3rd of this year. The next day, February 4th, Karen Reed files a motion to order requiring plaintiff's counsel to destroy inadvertently produced communication. You guys are going to love this one. This is wild. So Karen is asking the court to order the plaintiff's legal team to completely delete and destroy all copies of a very specific email. So on December 16th, 2025, Karen accidentally hit reply all to an email where she had been blind copied. This is why Llama has anxiety about emails, y'all. Okay? Because of things just like this, because I don't understand how they work. Now, because of this mistake, an email containing private, legally protected information about her defense was accidentally sent to the opposing lawyers. So, not great. Not great. Oh, his computer will stall out. Yeah, I mean, they made it sound like it's you need all sorts of stuff. Don't worry, he's got it. He's a know-it-all. Yikes. So they're like, oh shit. Should not have sent that to them. So Reed's lawyers asked the plaintiff's legal team multiple times to delete the email or at least set it aside until a judge could rule on it. But the plaintiff's lawyers refused. Yikes. Reed wants the judge to order the opposing lawyers to delete the email, destroy any copies, and make sure any copies shared with their clients or others are also completely deleted. All right. So she tried to just email her lawyer back, and instead it emailed everybody. And they're like, hey, this is protected conversation, attorney client, delete it all. And now the plaintiffs are being like, no, nope, we're not going to do that, which is a little wild, I think, but okay. So on the same day, then the plaintiffs file their opposition to that. And here's why. So the plaintiff's lawyers read the email before realizing that it was an accident. Oh, wait, hold on. We need a new slide. There we go. The plaintiff's lawyers read the email before realizing it was an accident. They claim the information she wrote contradicts the statements she previously made under oath. The plaintiffs argue they should be allowed to keep and use the email for the following reasons. That she waived her right to privacy. Wait, is that the right one? Oh, maybe I didn't put those up there. Oh, yeah, I did. There we go. I got too excited. So here's why they say they should be allowed to keep it. So she waived her right to privacy, her privilege, her attorney-client privilege. Now, normally communications between a client and their lawyer are completely private. However, the plaintiffs are arguing that Karen Reed and her team were careless and failed to take reasonable precautions to protect her privacy. Okay. Also, that it can be used to prove she is unreliable. They want to keep it for impeachment. Even if the judge decides the email should have stayed private, the plaintiffs argue they should still be allowed to keep it. If Karen takes the stand during the trial and lies or tells a story that matches her old statements, the plaintiffs want to use this email to prove to the jury that she is changing her story. I want to know what the email says, but I don't know what it says. And then, of course, the bell cannot be unrung, which is something you often hear when news gets out, right? You can't unring it. You can't put toothpaste back in the tube. The plaintiffs argue that because their lawyers have already read the email, they cannot simply forget what they saw. Well, you can't forget, but, okay. The plaintiffs are asking the court to deny Karen Reed's request to destroy the email. Instead, they want the judge to let them keep the email to use at trial and allow them to question Karen Reed under oath about what she meant in that message. And Karen replies back to that, and her legal team is basically like, this was a one-time honest human error, not a regular practice. They also argue that the plaintiffs don't even need the email to question her because the information matches what she already provided in her official sworn court response. They're like, just get rid of it. It doesn't matter. It's fine, is what they say. I don't know. I haven't read it, but that's what they're claiming. And then we got, what is it? Read pages 6 through 9. I wasn't sure how far I was going to get, so. Let's see. So these are the answers. Okay. So let me share this one over here. We'll just do this, and this will probably be it for today, friends. So these are her answers to the plaintiff's interrogatories, their questions, okay? So the question that they asked was, state all facts forming the basis for your claim that plaintiff's damages arise from the death of John O'Keefe were caused by acts or admissions of third parties for whom Ms. Reed is not responsible, as set forth in affirmative defense number 2 in your answer to the plaintiff's complaint. So answer number 2. Ms. Reed objects to this interrogatory to the extent it seeks information outside of her knowledge and possession. Ms. Reed further objects to this to the extent it seeks information subject to the attorney-client privilege. This was all repeat that she mentioned earlier, but she has went further into this. Below, I describe certain informations and facts of which I am currently aware. However, I believe there are additional facts and additional evidence that I do not possess, which will further support the referenced affirmative defense. To date, I have not engaged experts for a trial in this matter, and therefore the response does not take into consideration their opinions. Additionally, at trial, I will rely on my attorneys and experts to explain the evidence, what it means, and how it indicates who is responsible for Mr. O'Keefe's death. Other than knowing I did not hit John with my vehicle and that it was not me who killed Mr. O'Keefe, I am presenting my knowledge solely as a layperson who observed evidence obtained and presented in connection with the 2 criminal rights trials against me. During my criminal trials, multiple witnesses provided testimony supporting this affirmative defense. First, my counsel engaged a private investigator who took photographs of a cement-ridged curb just inside the garage, and the pathology expert my counsel engaged opined that Mr. O'Keefe's head wound came from a ridged ledge. Further, 3 separate doctors testified over the course of 2 criminal trials that Mr. O'Keefe's arm wounds were consistent with an animal attack. And my understanding is that the owners of the house at 34 Fairview, Brian and Nicole Albert, testified in the first criminal trial that the Alberts' dog, Chloe, never went into the front yard. Therefore, I believe Mr. O'Keefe was inside with Chloe. Next, Ian Whiffen, that guy, the Commonwealth's own witness, confirmed Mr. O'Keefe's Apple Health data showing 3 flights of stairs were climbed after 12:20 a.m. The Apple Health data also shows Mr. O'Keefe taking steps, enough steps to get inside the house at 34 Fairview Road in Canton. It's very interesting about the data that was provided and analyzed and talked about in the trials by all the different experts, because it was like, okay, well, either this is accurate or it's not. Like, either we can trust, that these steps were taken, or you're just saying no, that it could have been, those steps could have been logged by something else. It could have been logged from flinging him in the air. Well, if that's the case, then the steps data isn't very accurate, is it? It's a whole thing. If you haven't watched it, please do. It's very interesting. Now, Mr. Whiffen further presented evidence that Mr. O'Keefe's phone battery temperature stayed flat for 3 hours in the middle of the night at just under 50 degrees, which is too warm to have been outside in the snow, and then plummeted just before I found his body at 6 a.m. Therefore, the evidence supports the conclusion that Mr. O'Keefe was indoors before 6 a.m. I also understand that a stain on Mr. O'Keefe's sneaker had DNA from 5 male contributors. I understand that there were 5 males inside 34 Fairview Road in the early morning of January 29, 2022, and that no one saw Mr. O'Keefe outside before 6 a.m., including Lucky Lauren, a snowplow driver in the area during the relevant time period. Lucky. In addition to these facts, the individuals inside the house at 34 Fairview Road in the early morning of January 29th also took actions that strongly suggest wrongdoing, including tampering with, destroying, fabricating, and manipulating evidence, all in a concerted effort to direct blame towards me. At the same time, the individuals and entities who had the responsibility to fully investigate the circumstances of Mr. O'Keefe's death, including the MSP, Canton Police Department, and Norfolk District Attorney's Office, and their respective officers, troopers, and employees, failed to adhere to their duties and instead ignored, destroyed, and failed to gather or investigate highly relevant evidence in and around the house after Mr. O'Keefe's body was discovered. They did so because of, among other things, personal connections between the lead MSP investigator, Michael Proctor, and individuals within the house. Proctors and other investigators' inherent bias, the occupant's connection to various local, state, and federal law enforcement agencies, the individuals in the house that night engaged in a concerted effort to direct the investigators' attention away from themselves and towards me instead. Accordingly, based on the information and evidence available to me, I believe that one or more of the occupants of the house at 34 Fairview during the early morning hours caused Mr. O'Keefe's death. However, as a result of the destruction and concealment of key evidence, the truth about what happened to Mr. O'Keefe has been deliberately obscured, and I do not know which specific individual or individuals within the house fatally wounded Mr. O'Keefe. What I do know without any doubt is that I played no part in causing, participating, or contributing to his death in any way. So she had sent that in on February 1st of this year. So there is that. And then let's go back to sharing this one. And I'm going to just cover just a few more things, it looks like. So February 6th, the judge does an endorsement on the motion for order requiring plaintiff's counsel to destroy inadvertently produced communications. So they're like, he's like, yeah, let's not do that. Then on the 11th, February 11th, this is the list of Karen Reed's notice of depositions, everybody that she plans on deposing and are expecting to start them in March of this year. You got Sean Good, who we already talked about, Kevin Albert, Courtney Proctor, Michael Proctor, Canton Police Department, Colin Albert, Yuri Buchanek, Brian Tolley. This is like a down memory lane of the trials because all these people testified at one point or another. Brian Tolley, Massachusetts State Police, Allie McCabe, Carrie Roberts, Julie Albert, Brian Higgins, Nicole Albert, Matthew McCabe, Jennifer McCabe. She's just a normal mom, guys. She's just a soccer mom. Paul O'Keefe, John O'Keefe II, Margaret O'Keefe, and Margaret O'Keefe. All right, so that is where we are going to leave off for today, because when we come back tomorrow, we're going to be right back into all of this, starting with another conference, the one the judge just said we were going to have a week later. Hi, Rob. Hey, Rob. Sorry, I'm getting ready to leave for now. I'll be back on True Crime and Wine Time at 2 to watch the first Murdaugh hearing for his retrial. That was a month ago before the next one that's coming soon. But so tomorrow we will pick back up where we left off in February of 2026. It's going to be a long one tomorrow. So we should be able to get through a lot of it until then. I appreciate you all being here with me today. I hope you enjoyed the spreadsheet, or I'm sorry, the slideshow. I hope that helped you out a little bit. I know it did me when I was putting it together. Like, oh, okay. But we do have lots of things to watch, lots of things to read that are kind of essential that I thought, well, it's not going to do us any good just summarizing them. So whether or not we get through the O'Keefe v. Karen Reed before the hearing on Thursday, we'll at least get caught up, even if it's right afterwards. There's like I said, a lot to go through, a lot to go through, quite a few hearings, a lot of text and emails to read. So it's definitely getting crazy over there in the O'Keefe v. Reed. So I'll be back tomorrow, 10 a.m. right here on Couch Court with Llama. So if you haven't, please subscribe, hit the notification bell. If you're on part of the replay crew, don't forget to like, or you can leave a comment below and let us know your thoughts about the O'Keefe v. Karen Reed lawsuit. So thank you all for being with me today. Make sure you go check Terry out over at True Crime and Wine Time. She's doing a midday missing episode today. And then I'll be on over there at 2 with Terry to talk murder. So lots of stuff going on all over the place. How do I keep it straight? I don't know. I know it's very early for you, Rob. It's okay. You're forgiven. You're forgiven. All right, friends. Until next time, as I always say, go forth and be amazing. All right. Bye, friends.